Adeze Nwosu was 38 years old when her husband of 6 years filed a motion in Fulton County Superior Court demanding 90% of all assets held in her name, on the grounds that her success had been built on the foundation of his support, and that the foundation deserved compensation proportional to what it had made possible. The motion used the word equitable 11 times. Adeze counted them. She was a contracts attorney by training, and precision was a professional habit she applied to everything, including documents that were wrong. The judge reviewed the motion on a Thursday morning in November. The hearing lasted 47 minutes. Adeze's counsel presented the prenuptial agreement, the independent asset valuations, the full business history of Adeze's consulting firm, which she had founded 4 years before she met her husband, and the timeline of every significant financial decision she had made in the 9 years prior to the marriage. When it was over, the judge looked at the motion and looked at the evidence and delivered a verdict that took 3 sentences to complete. Darnell Okafor wept at the defendant's table. His attorney placed a hand on his arm. Adeze gathered her documents and put them in her briefcase with the same care she always used with documents she intended to keep. She did not look back. What Darnell had never understood, in 6 years of marriage to a woman who came home from 16-hour days and made dinner anyway and kept the household running with the same disciplined attention she brought to her most complex contracts, was that Adeze Nwosu had built her life as a structure, deliberately, load-bearing, with full awareness of which elements were weight-carrying and which were decorative. He had always assumed he was a weight-bearing element. He was decorative. The distinction, as the court had now confirmed, carried significant legal consequences. Her consulting firm had generated $2 million in the prior fiscal year. Every dollar of it was hers. Before we jump into the story, comment where in the world you are watching from, and subscribe because tomorrow's story is one you need to hear. The firm had started in a second bedroom in the Decatur apartment Adeze had rented the year she passed the bar. She had 2 clients in the first month, 3 in the second, and by the end of the first year she had built a practice in commercial contract review and dispute resolution that was modest enough to fit in that second bedroom, and already more than she had been promised it would be by everyone who had advised her, gently, to join an established firm instead. She had a way of seeing the interior architecture of a contract, the places where language created exposure, the clauses that looked protective and weren't, the structures that seemed sound and had been built on assumptions that would not survive the first serious dispute. That was difficult to teach and impossible to manufacture, and her clients knew what they were getting when they retained her and they told other people. Her father had told her once, when she was 16 and building her first argument in the school debate program that he had driven her to every Saturday for 2 years, that the person who understood the rules better than everyone else in the room was the one who decided what happened in the room. He had been a civil servant in Atlanta for 30 years, a man who had built a career on the careful and complete understanding of regulatory frameworks and who had watched his daughter read every set of rules she encountered with the specific hunger of someone who understood that rules were not constraints but instruments. He had been quietly and completely proud of her in the way that certain fathers were, present at every milestone, saying little, meaning everything. He had met Darnell twice before the wedding. He had said at the rehearsal dinner that he hoped Darnell understood what he was being trusted with. Darnell had smiled and said, "Of course," and her father had nodded and said no more, because her father had never been a man who used 2 sentences where one would do, and the one had said what it needed to say. She had met Darnell at a professional conference in Savannah in the spring of the year she turned 32, at the kind of networking reception where the food is better than the conversation, and the conversation is better than the outcome, and both are better than the alternative of spending the evening in your hotel room reading case files. She had been at the reception for 20 minutes when he introduced himself, which was 20 minutes longer than she usually stayed at these events. He had a quality of attention that she did not encounter often. He asked about her work, and then asked a follow-up question that demonstrated he had actually heard the first answer, which was more than most people managed. He was interesting company. She had exchanged cards with him at the end of the evening, and thought, on the drive back to her hotel, that she would probably hear from him, and that she was not opposed to that. She had been careful about the prenuptial agreement, which she had presented without apology 3 months before the wedding at a dinner she had chosen for the purpose, because it was quiet, and because she believed that important conversations deserved settings that were not rushed. She had explained every clause, answered every question, and provided him with the contact information for an independent attorney she recommended he retain for his own review. He had retained counsel. The review had taken 6 weeks. Darnell had signed on a Tuesday morning in February, and had said, with the ease of a man who did not believe the document would ever matter, "You know this doesn't change anything between us." She had said she knew. She had believed, at the time, that she did. At the time, she had read the signing as understanding. She understood now that it had been miscalculation on his part. He had signed because he believed that the life they would build together would make the premarital distinction irrelevant. Because he had not yet understood that Adize Nwosu did not build things that became irrelevant. The first 2 years of the marriage had been good. That was the honest accounting, and she had no interest in revising it. Darnell was present and engaged, and he came home at reasonable hours and asked about her cases with what seemed like genuine interest, and cooked on the weekends with a real pleasure that she had always respected in a person. The willingness to do something with your hands just because the doing of it made something good. She had liked coming home to the smell of cooking. She had liked the way the house on Kirkwood felt in those years, like a thing 2 people were making together from separate and compatible materials. In the 3rd year, something shifted. The shift was gradual, and she had documented it in the precise internal way. She documented everything, not in writing, not yet, but in the way a contracts attorney stored language, accurately and verbatim, because you never knew when you would need the exact words, in the exact order they were said. He began talking about her firm as though he had built it, not loudly, not in ways that could be cleanly confronted, but in the way that certain people corrode a structure over time, small adjustments, minor revisions of the record, the slow and patient replacement of the true story with a story in which his role was larger. He told the story of how the second major client had come through his network, rather than her decade of professional reputation. Told it often enough and in enough different rooms that it had begun, she suspected, to calcify into something he appeared to believe. He used the phrase "our firm" at dinner parties in a way that she absorbed without correcting, because she had not yet decided what to do with it, and because she had learned, in 20 years of professional practice, that the premature identification of a threat was itself a kind of error. He had introduced her once at a cocktail party in Inman Park as his wife who ran a small legal practice. She had stood beside him and received the introduction with a pleasant expression, and had said nothing about it in that room, and had filed the exact language in the place where she filed things she intended to return to. She had also noticed, in the 4th year, a pattern of financial proposals that were individually reasonable in isolation and collectively revealing when mapped across time. A shared investment account that he proposed putting in his name for tax efficiency. A business expense reimbursement arrangement that he suggested running through a personal account he controlled, which would have created a documentation trail that described the firm's expenses as jointly managed. A suggestion, floated twice, that she consider adding him as a named partner in the firm in an advisory capacity, floated casually the first time. More specifically, The second time, with the name of a colleague who had done something similar with his spouse as a reference point. She had recognized the escalation pattern. She had been trained to recognize escalation patterns. She had declined each request with professional efficiency and had noted the date and the substance of each conversation and had retained Vivienne by the end of that year. Her attorney's name was Vivienne Marsh, and she had been in family and civil law in Atlanta for 24 years and had a reputation that Adizay had researched before she made the call and that had confirmed what she needed confirmed before she committed to anyone. Vivienne's office was on the 14th floor of a building in Midtown, with a view that on clear days extended south toward downtown, and that Adizay would come to know well over the following 14 months. Vivienne listened to the full account in their first meeting without interrupting, which took 40 minutes, and at the end of it she said, "Tell me about the prenuptial agreement." Adizay described it in full. Vivienne asked 4 questions, each one more specific than the last, the way a person asks when they are assembling a picture from known pieces and checking the places where the picture could develop gaps. Then she said, "It's sound. What he is attempting to construct, the advisory relationship, the shared accounts, the pattern of narrative revision, is an attempt to establish a record of contribution that would complicate the prenuptial protections in a dispute. He is building a counter-argument to a document he has not yet decided to fight." Adizay said, "He will decide to fight it." Vivienne said, "When he does, we will be ready." They had been ready for 14 months before Darnell filed. Adizay had kept records during those 14 months with the same discipline and precision she brought to her most complex commercial contracts. She had dated and documented every conversation that touched on the firm's ownership, the financial arrangements, the narrative revisions, the social introductions that described her firm incorrectly, the partnership proposals, the account restructuring suggestions. She had kept a contemporaneous log, each entry time-stamped and worded with the precision of someone who understood that the log might one day be read by people trained to find imprecision and use it. She had asked Vivienne to review the log quarterly, and Vivienne had suggested additions and clarifications that made it stronger. She had also retained a forensic accountant named Constance, who had spent 11 years in financial fraud investigation before going independent, and who Vivienne used regularly for matters where the financial history needed to be not merely accurate, but unassailable. Constance spent 6 weeks on the firm's complete financial history. Her report was 43 pages. It traced every significant revenue event, every client relationship, every professional connection that had contributed to the firm's growth, and it attributed each element to its accurate source, which was, without exception, Adizay's own work, her own relationships, her own professional reputation built across 15 years of practice. The 2 client inquiries that had come through Darnell's network during the marriage were in the report. Both had declined to retain her. The report noted this in a single, unembellished sentence, which was the only treatment the fact required. Constance's report was organized chronologically, cross-referenced by entity and account, and it contained not a single ambiguous sentence. Adizay had read it twice, and had found it accurate and complete, and had felt, reading it, the particular quiet satisfaction of someone looking at a structure they had built, and finding it sound in every dimension they had designed it to be sound in. Real power operated in quiet rooms, and the most important room of all was the one where the documentation lived. The motion arrived on a Monday morning, delivered by courier to her office. Darnell had retained counsel, a firm that specialized in high-asset divorce and that had a reputation for aggressive pre-trial positioning and for motion practice that was designed as much to unsettle the opposing party as to prevail on the merits. The motion was 40 pages. It argued at length that the firm had grown substantially during the marriage, and that the growth represented marital contribution, and that the social capital and professional introductions Darnell had provided through his own network constituted a quantifiable economic contribution to that growth, and that the prenuptial agreement failed to account for ongoing contribution of this kind and should be treated as inapplicable to the disputed assets. The word equitable appeared 11 times. Adaize counted them on a yellow legal pad, because counting precise repetitions in legal documents was a habit she had developed in her first year of practice and had never seen reason to abandon. She made 7 additional notes. She called Vivienne when she was finished. Vivienne said, "I've read it." Adaize said, "They're relying on the contribution argument." Vivienne said, "They're relying on a contribution argument that requires the court to accept a set of factual premises that our documentation directly contradicts at every significant point." His network produced 2 client inquiries during the marriage. Both declined to retain you. The firm's growth during the marriage is fully accounted for in Constance's report and is attributable to work you performed and relationships you built before and during the marriage through your own professional practice. There is no marital contribution claim that survives contact with the actual record. Adaize said, "Then, we present the record." Vivienne said, "Thursday." The hearing was on a Thursday in November, in a courtroom on the 5th floor of the Fulton County Courthouse, with tall windows on the west side that let in the kind of autumn light that made the room feel more certain of itself than most rooms did. Vivienne presented the prenuptial agreement first, walking through its execution history with the patience of someone who understood that documents needed to be introduced before they could do their work. Then, the independent asset valuations. Then, Constance's 43-page financial history, key sections read into the record in a sequence that built a case, the way a well-drafted contract built a case. From definition through obligation through consequence, each step supporting the next without gap or ambiguity. Darnell's counsel made their case. The judge listened. Adaize sat at the table, with her hands folded and her breathing even, and her attention on the judge's face, which told her what she needed to know about how the argument was being received before the argument was finished being made. When it was over, the judge spoke for less than 2 minutes. The prenuptial agreement was valid, properly executed, applicable in full. The contribution claims did not meet the evidentiary threshold required to displace the agreement's protections. The petition was denied. Darnell made a sound at the defendant's table, a single, compressed sound that was the beginning of something that became. In the following seconds, weeping, his attorney placed a hand on his arm. Adaize put her copy of the ruling in her briefcase with the same care she always used with documents she intended to keep. Closed the briefcase, stood, and shook Vivienne's hand. She walked out of the courthouse into the November air and stood on the steps for a moment. The city was doing its ordinary business below and around her. She was not triumphant. She was complete in the way you are complete when you have done the work correctly and the work is held. She called her father from the courthouse steps. He answered on the second ring in the way he always answered her calls, promptly, as though he had been waiting for something he knew would arrive, and she said, "It's done." He was quiet for a moment. Then he said, "How did they rule?" She told him. She described the judge's exact words because her father was a man who wanted the exact words rather than the summary, and because she had remembered them precisely, which she always did with language that had mattered. He was quiet again for a longer moment, the quiet of a man whose satisfaction was so complete it had nowhere to rush to. Then he said, in the voice he used when something had happened exactly as it should have, the person who understands the rules. She said yes. He said, "Come for dinner Sunday." She said she would. She and Vivienne had coffee afterward at a restaurant 2 blocks from the courthouse, sitting at a table by the window with the city going about its ordinary business outside, and Vivienne described the appeal timeline in the practical, forward-looking way that Adeze had always valued about her, never dwelling on what had just been won, always already preparing for what came next. They talked for 40 minutes. When they finished, Vivienne said, "You documented this better than most attorneys document their own cases." Adeze said, "My father taught me that the record was the only thing that outlasted the room." Vivienne said, "He was right." She walked back to her car. She drove to her office. She had a client call at 3 and a contract review due Friday, and a firm that had generated $2 million in the prior fiscal year, and that was entirely, completely, without qualification, hers, 10 months later. On a clear October morning, Adeze's firm had expanded into the adjacent office suite that had become available in February, adding 400 square feet and a proper conference room, with east-facing natural light that she had furnished herself over a Saturday in March. Choosing each piece with the same deliberate attention she brought to every decision she put her name on. She had rehung her father's photograph on the wall of the new space, beside the window, where the light came in at the angle she had planned for when she specified the window treatment to the contractor. She had hired a second associate, a young woman named Priya, who had finished at the top of her class at Georgia Law, and who had the same capacity for reading the interior architecture of a contract that Adeze had identified in herself at Priya's age. Not the ability to process legal language, which could be trained, but the specific instinct for where a contract's assumptions were doing more work than the language around them, where the structure was carrying weight it hadn't declared. That quality was either present or it was not. In Priya, it was present. Adeze was mentoring her with the fullness of someone who understood exactly what the right kind of attention had been worth when it had been offered to her. Darnell had relocated to Charlotte in the spring, where a regional marketing firm had offered him a position. She had heard this from a mutual acquaintance, who mentioned it without affect, the way neutral information gets passed in professional circles, and she had noted it and moved on. His counsel had filed a notice of intent to appeal in December. Vivienne had addressed it comprehensively in a brief submitted in January, and in March, the appellate court had issued a 2-paragraph denial that Vivienne described, in her characteristic understatement, as definitive. The word equitable did not appear in either paragraph. His mother had called Adeze in April, which Adeze had not expected, and which had lasted 12 minutes, and which had been, on the older woman's part, an act of courage that Adeze had recognized as such. The woman had said what she understood to be true about what her son had done, and she had not softened it, and she had not asked for anything in return for saying it. Adeze had listened to all of it, and had said, with accuracy, that she held no bitterness. Bitterness required ongoing investment in people who no longer warranted it. She had always been precise about where her resources went. There was a man named Jerome who had come into her life through a client introduction in the summer, a structural engineer who worked in historic preservation and whose professional relationship with the built world had a quality of genuine devotion that she recognized and respected. He had asked, at their first dinner, what the most interesting contract dispute she had ever handled was, and she had told him the story of a commercial lease renegotiation in her 3rd year of practice that had turned on a single subordination clause, and he had listened for 20 minutes with the specific quality of attention that people who are genuinely engaged bring to subjects they had not encountered before. He was deliberate and unhurried. He said what he meant and meant what he said. He had not once in 4 months given her reason to make a note about anything. She was not in a hurry. She had never done her best work in a hurry. On that October morning, she was at the kitchen table in the house in Kirkwood with coffee. The morning light coming through the east window the way it came through only in October. Low and generous and honest. She had a client meeting at 10. She had a contract review due Monday. She had the expanded office, and Priya and the firm that had been built on her work and her work alone, and she had proved in a Fulton County courtroom, to the satisfaction of a judge who had reviewed every document in the record, that it belonged to her in full. She pressed the coffee mug between both palms and looked at the morning coming in. The light was doing what October light did in Kirkwood, arriving at a low angle through the leaves of the oak tree she had insisted on keeping when the contractor had suggested removing it for easier access to the side of the house, the tree that now threw a pattern of shadows across the kitchen floor that moved throughout the morning as the sun moved. A clock she had never needed to set. Her father had told her, the person who understands the rules better than everyone else in the room is the one who decides what happens in the room. She had understood the rules. She had built the documentation 14 months before it was needed, and when it was needed, it had held every load that was placed on it. Without gap, without ambiguity, without a single sentence that required explanation or defense. She was free. She was solvent. She was unbothered. I hope you enjoyed that one. Be sure to like the video and subscribe so you don't miss the next story. I've picked out 2 more for you that I think you'll really like.